The appeal is dismissed.
But you have to mention for listing of an IA in connection with criminal appeal number 114/2000.
IA for suspension.
Suspension.
When do you want?
Okay, Monday. I filed an additional affidavit notify anything with medical documents. So he is seriously ill, and now he is admitted in Morigo City.
Working days. Okay. Okay, with the urgent Monday.
Another fair logic, the last, it was filed of 3/1/2025 for admission appeal notice.
Filed on?
3/1/2025.
Not listed.
Not yet listed.
Why? It must be in defective or something.
Okay.
Find it. Otherwise, you can have it on Monday, Wednesday, whenever. New matters, no problem.
Please give us. Application. That paper listing of the criminal appeal. Last three matter was listed on 2/4/2025.
2/4. For what? Was it listed for what purpose?
I was already completed.
Paper book prepared. What was the order passed? It might be an order for listing after preparation of the paper book.
No, the last order was that, and a matter hearing was appointed, and accordingly, this matter was listed after one.
After one. Okay. Let us. Okay, Wednesday next.
Exam number 20, my lord.
Yes.
There has been an IA, it has come for hearing, my lord. The author process.
20.
Yes, my lord. There is an IA being pending, my lord. Again, my lord.
Yes. Okay.
It will be taken up after the orders order, my lord.
You want to press the IA?
Yes.
Okay, yes, madam.
In fact, for IA madam also, IA also mentioned like that for 18 and 22.
These are all connected.
All are connected. That is also best today for me. That is for the hearing madam, best IA madam. So simultaneously we can do that.
IA.
Pending.
Otherwise, paper book prepared.
Paper book prepared, but for the several times paid madam because it is that is sealed by her. So sometimes time. We'll see what we.
I, as far as Mr. Mia is concerned, is with regard to the juvenile.
Juvenile.
The report is there,
Yeah.
and the report says that he is not a juvenile. No.
No. Says that that particular birth certificate which we have annexed, they could not find out anything in regard to this. And on the last occasion, learned PP has made a fair submission that the only alternative is for ossification case. That's it.
We can direct ossification.
Yes.
But Mr. Chaudhary, to be very frank, this bench will not be available next week. So a long hearing probably will not be possible. But one more small short hearing. Huh?
It is for suspension.
No, since the paper book is prepared. So far as Mr. Mia is concerned.
For not 1 year, but I is coming again and again, madam, but actually not thinking of for this year. We'll see it out and see very possible, madam.
We are taking up matters, your matters are also taken up. We are not that they are not taking up matters. Somehow it's left out. We'll have it next week. See, let us see. Mr. Bhiya's case is a different case.
That is another aspect.
But if you are praying for a suspension on the merits, paper book is prepared. Ideally is to go for the hearing of the matter. We decide let it reach.
I didn't want.
Foxlo. Foxlo.
Yes.
Okay. Heard. 3 BKs and learned legal aid counsel for the appellant who has preferred the appellant to institutions. Admit call for the records. Ms. Jahan, learned ATP, accept notice on behalf of the state respondent. Steps for service of notice upon the respondent to be taken, which is to be routed to the office, office of the PC, stepped into this list of the 66 along with service report as well as report on receipt of records. I connected appeal admitted today, issue notice, steps same button to the office, list of the 66 for service report as well as for filing objections. इसमें records जरा नहीं चाहिए. Okay. We have no issue notice.
Item 2. This is statutory appeal, my lord, against the conviction, life, and other final cases.
Or under what section? Council. All this appellant was referred to perfect understanding against something. Admit call for the records. As Jahan, one state, second option in normal steps to be taken for response number 2 in the manner prescribed. Procedural nature is, steps within 2 days. Okay. 6 weeks for service report as well as for receipt of records. Report on the receipt of records.
Record.
And
I have for paying.
issue notice. Issue notice 6. Take steps.
Item 3.
Under first one. First one. इसमें legal aid council में ये better चल. You have an IA also?
No, I don't know. I have.
6 weeks. You take steps which should be routed through the office of the PP. Regular appeal.
Regular.
Where is he? And Hassan. And Hassan.
Can take it to office sometime. Monday.
Hassan, non-appeals for the appeal. Hassan.
No, Your Honor.
Yes. What is your name?
Yes,
You have, where is your brief? This is your brief. Yes, Hassan, no? Conviction under what? Oxford. First order. We're admitting it. I need 6 weeks. 6 steps to the office of the PP. Yes, Hassan.
Item 5.
Item 5, yes. Have it for hearing? Criminal appeal of 16.
Okay.
Why?
Very good.
No, we'll definitely do. Why is it pending for 16? We are taking 22 matters, 23 matters. Why is it left out? What about the respondent number 2? Third. What is the conviction under? Conviction under?
324.
No, not POXO. How much is the conviction? Why has it come for a DP? It was before a single bench. It was moved before a single bench on 2/8/2016. It has all along come before a single bench. Suddenly it came before a division bench. Why?
Convictions are 1 year and 3 months. Abdul Rahman is for 1 year. And the other one is convicted for 3 months.
Okay,
Wrongly listed.
this matter appears to be wrongly listed before us as it should be listed before the honorable single bench. In fact, the admission was done by an honorable single judge on 2/8/2016. The para office accordingly lists this matter for hearing before the appropriate bench.
Item 6.
Yes,
They have withdrawn the reminder.
now,
Anyway, the judgment has been passed, ignoring the direction of the apex court in.
Rajesh Neha,
Yes, sir.
yes.
So Lordship, this matter might be remanded back, let them submit statement of assets and liabilities and.
You can file, submit here also, we can also decide.
I understand. They will use some quorum. In case they get aggrieved by the author of the lawyer's file, they will at least support the competent.
No, you already have a judgment. You are in appeal. This is not a original suit before us. Preliminary will decide.
Finding the matter to the.
Ahad V.K. Das, learned counsel for the appellant, as well as Dr. P. Agarwal, learned legal aid counsel, appearing for the respondent. Sarah, pursuant to the earlier directions of this court for payment of the area maintenance, Dr. Agarwal, the learned counsel, has informed that the area maintenance, which was deposited in the registry of this court, has been withdrawn. Sarah. Both the learned counsel for the parties are in agreement that it is only the aspect of not adhering to the requirement of law as per the Honorable Supreme Court in the case of Rajneesh versus Neha reported in so and so, that the learned counsel.
The only district of not adhering to the requirements of law as matter on the in the case of Rajneesh versus Neha.
Which is the subject matter of dispute. So both the learned counsel have jointly prayed that on the aforesaid respect, the matter may be remanded to be remanded to the learned trial court for taking a decision by adhering to the said principles. The aforesaid submission has been duly considered. In the case of Rajneesh versus Rajneesh Supra, the Honorable Supreme Court has laid down the requirement of filing of assets and liability of the respective parties, including other other facets. For ready reference, the relevant observations are extracted here and below. It is not in dispute that the parties were not directed to file assets and liability statement by way of affidavit by the learned trial court. In view of the above, we are of the opinion that interest of justice will be served if the matter is remanded back to the trial court, namely Principal Judge, Family Court, Kolkata, who would take charge of the proceedings and direct the parties to file the assets and liability statement in the manner prescribed within a specified time, and thereafter decide the matter in accordance with law. It is needless to state that any decisions taken can be the subject matter of challenge by either of the aggrieved parties. As this court has not expressed any opinion on the merits of the case. What is the
So should the IM was for withdrawal of the amount?
I have been disposed of?
That, this IM was for pay of the incident.
In view of the final orders passed insurance, more orders are required to be passed, I exclude. Okay. Our records have come, madam.
But I don't think they've arrived.
I mean, the records are to be transmitted back immediately. Okay.
This is.
I didn't submit.
They've gone. In conviction under? POCSO. POCSO, you are pressing, taking a huge risk. Records have come. I was very serious with pressing the IA.
After going with the all record statements of
Victim statements recorded, 164. And regarding the age, was there any dispute with regard to the age? How was the foundational facts laid down?
That is admitted in school in class 2 is coming for other school, but there is no any record.
No, how was the age proved?
There is no proof, they say that certificate is given on the basis of exam.
No ossification is done. What was the age as determined by the prosecution?
So my father says it is 14 and she says 15 and headmaster is given 15 on exams. There is no record.
Yes.
It is 14 years every May. 15 years was on the date on which the victim gave her deposition for the learned trial court. And there is a.
As a witness.
And the learned trial court has said that on the date on which she gave her deposition, she was 15 years old. On the date on which the occurrence took place, the incident took place, her age was 14 years. So it was consistent. The father has also testified that her age.
Well, I think that is doing the argument.
No, she just pointed out, she is not doing the argument. See, age, as per 94, there are 3 methods.
Right.
Birth certificate, school certificate, ossification test.
Yes.
Now there is a certificate which you are trying to dispute.
Dispute minor headmaster is specifically stated that there is no record in the school minor register and she is coming in the other school, but at that time other headmasters are there, they will not put any there. And he is given the.
You had put questions to the headmaster. He had used evidence. As PW?
It will be minor.
4. What did you elicit in the cross examination?
Cross examination said that I have been serving the same school since 2009. There was no date of birth of the school record. Lakshmipur got admission in class 2. Another person was headmaster when Lakshmipur got admission.
In which year she had taken admission in class 2?
She did not bring transfer certificate when she came to my school. I put the age Lakshmipur on exam.
Okay, no. The class 2 admission was in which year?
And then from that.
No, the register will be there. Huh? What was proved?
Group by the previous.
Where you are reading from which part? Which part?
Page 27.
27 of your paper of your IA.
I page 27.
27.
There. I know the complainant symptom group. I know actually particular days were present in the dog. I know.
Who is this Bharat Kalita? Who is this PW phone?
Bharat Kalita is the headmaster principal right of the school.
Then what does it say?
Right.
He says something else at page 31.
Page 31.
Yes. I issued school certificate to Lakshmi Gaur. After going through the records, I showed the age as 15 years. Lakshmi Gaur has no birth certificate. Exhibit so and so is the certificate. That has been proved. See, there are three methods. There may not be a birth certificate, there will be a school certificate. There may not be a birth certificate, there may not be a school certificate. Then you go for authentication then. Now there's a school certificate.
The school certificate is there by the police given on the basis of.
Now, but what about the deposition of PW4?
Yes, PW4 is the headmaster by the state.
Yes.
I have been I have been serving the state school since 2009.
That's it. You have put a question that how did he put the age? He said an assumption.
Yes.
Will it make out a case that yes, you need to be given the benefit of doubt?
Definitely, minor because of that, my lord. If the record is not there.
Now, do you have anything to show? See, there is a presumption of 29. We know that a presumption will not automatically be invoked unless the prosecution lays down the foundational facts. Now, there has to be something with you to show that the victim will not fall under the Boxer Act. Do you have anything?
The doctor is also not any
Where is the doctor? And that we have seen, Headmaster Polita. But here, Mr. Bora is trying to emphasis upon the cross-examination, which he has all the right. He says, no doubt, that I had put the age on the basis of assumption. That is there.
On the other hand, my lord, property is one other thing is that if after 6 months, while during 6 months, my lord, it reveals that she is pregnant, and thereby the smell was made. And at that time of the 3% names are mentioned. That is reflected.
Can you read the vernacular regarding the assumption part?
Yes.
At page 30. Record or.
Sonamor Tarik Nafi.
Record or.
Sonamor Tarik Nafi. দ্বিতীয় মানৱ লক্ষী গড়ে ভৰ্তি কৰিছিল। লক্ষী গড়ে ভৰ্তি হওঁতে প্ৰধান শিক্ষক অন্য এজন আছিল। লক্ষী গড়ে আগতে ক'ত পৰিছিল ক'ব নোৱাৰো। মোৰ স্কুললৈ আহোঁতেনে ট্ৰেন্সফাৰ
Certificate.
ট্ৰেন্সফাৰ চাৰ্টিফিকেট অনা নাছিল। লক্ষীগড়ৰ বয়স মই অনুমানত দিছিলো। লক্ষীগড়ৰ চাৰ্টিফিকেট মই ইমান তাৰিখে
What has been proved?
birth certificate is given by the exhibit EC is given the exhibit certificate. Another point is settled by the first.
Where are the statements of the victim?
Victim by the page PW3 page 23. Victim is stated by the as per going to the statement. By the there is by
The jar was lost by the mother.
father. Oh, my love, father stated there.
Let us see where Where is the victim? Which page?
PWC.
26 or 27? 27. Fifteen years while deposition. And her 161, 164? 164 would be there. Records have come. Well, let the paperwork be prepared. We'll have this IA pending. We'll not dispose this of. Let the paperwork be there.
In cross other states there. Before going to the police station, there is a place. One. Uncle says that when placement is the owner is written to the complainant by the victim, and that at that moment the person's names are mentioned. One and two is different. Third is the and that was corroborated by the special system also. At that time, we were present that when UN guys in this all players have come and beating to the complainant and complainant victim and victim stated to others. And third is the investigator. And they also come demanding land. The one. That aspect is also.
No, if the aspect of minority is established, then other consideration will not have any bearing at all. If the acquisition is under the POCSO Act, the age is within the prescription of the law, then other consideration, whether there was minor.
Other names are even in nearby house, one part of the name.
But her deposition we have seen as PW3, she has only named you.
One statement for the police. They did not say anything against.
But what is your cross-examination?
That is cross.
What is the purpose of 161? Only to give you an opportunity to confront the witness. It has a great meaning, 161 for the defense. You use it, confront the witness. That this is your statement with the police. Contradict. Contradiction I has contradicted. Where is I?
Below 7.
40.
Below 7. Not this down.
40
For the PW7.
pages are not heading. PW7 is 44.
On 7/7/2022, I was serving as intern of Department of Police Output. That day, a person Kulton group by name Northern Azhar. The Azhar was forwarded to Sophia Police Station, Sophia Police Station, Azhar, and entrusted me with a having received the charge in this, I questioned complainant Kulton board at the output system and recorded his statement.
Come to page 46. He did not read it aloud, but see, it is only the place where the contradiction is there, not the drain, but in the tea garden. The substantial allegation is there. Page 46, first part.
Question of 3 more and recorded her statement at the house of the follow. Then I visited house of the I took
Okay, paper.
the medical report is being collected.
Heard 3 and what are learning counsel for the applicant. Also heard Miss B. Bhuya learned APP Assam whereas Dr. P. Agarwal, learned amicus curiae, is present for the respondent number 2. Correct? We borrowed the learned counsel has submitted that there is serious discrepancy with regard to the age of the alleged victim, and thereby the application of the POCSO Act would itself be in doubt. He has drawn the attention of this court to the deposition of the headmaster, wherein the aspect of putting the age on the basis of assumption has been highlighted. He has also submitted that the victim herself in her deposition was not consistent with her earlier statement made to the police, and this contradiction has come overboard in the deposition of the IO. Sir. On the other hand, both Ms. Bhuya, the learned APP, and Dr. Agarwal, the learned amicus for the respondent number 2, have submitted that the aforesaid contention made on behalf of the applicant is not based on records, as there is no manner of doubt regarding the age of the victim and the consequent application of the POCSO Act. In any case, they have submitted that in any case, since the records have come, the appeal itself can be heard after preparation of the paper. The rival submissions have been duly considered. We are of the opinion that while keeping the IA pending for consideration, the paper book may be prepared, which would come handy for consideration of the matter. We accordingly direct the registry to prepare the paper book expeditiously and list this case for orders immediately thereafter. How many witnesses? 7. DW4? DW4? Who are the DW? Understood. Who are they? Who are they? For what purpose? Age or what? Two others. 7 plus 2, 9. 7 plus 2, 9.
There is a task case, can we take it up 50 days time?
15 days paper book will not be. What is the ailment? Have you given? Have you filed an IA for that? You file an IA, we'll consider. If that is the case, we'll consider. We can for a limited period we can consider. You file. No, that is an independent cause of action. It's not before us. You file it. File it, mention it. We consider, at least allow for consideration. Whether we allow the prayer or not, that's a different matter. I didn't. Yes. Yes, what is this? Objections filed, madam.
Yes, I have 5 minutes.
Objections filed by the state. Hmm? Now conviction under what section? 302. Now, you are pressing this IA on merits of the case or some other consideration?
In this case, my lord, witnesses were found.
No, you are on the merits. Is it strictly on the merits or is it on other consideration like somebody is ill in the family or something like that? If it's on merits, you have to make out a very prima facie case that gross miscarriage of justice has taken place. Independent witnesses not examined may not be a point for consideration at this stage.
Why not,
Paper book prepared.
Yes.
You prepare the paper book, press the appeal, we'll have it, give you a date. Okay. Heard Sri J.C. Gogoi Learned Counsel for the applicant / appellant. Also heard Ms. S. Jahan, the Learned APP Assam. Conviction under what? Procedural 2. He has made the private respondent. Has anybody appeared? No, we can, but since he has made a party, we just want to ensure. You have received the paperwork, Mr. Gogoi? You have not received.
I have.
Uh, Office note dated 4/10/2023 reflects that response number 2 has been served. The same has been accepted. The same is accepted. It also appears that the paper book has been prepared and copy of the same has also been collected by the learned APP. Let the learned counsel for the appellant be furnished with the copy of the paper book for which he will coordinate with the concerned office. Since the paper book has been prepared, we are of the opinion that instead of considering the IA, the appeal itself can be heard. We accordingly direct listing of this appeal for hearing in the third week of June 2025. Third week. Come prepared, take the paper book immediately. Item 9. Yes, madam.
Last occasion, Mrs. Secretary, the IO report stated that the parents of the patients are they are in judicial custody. So Yona has just a 2 weeks time for the actual Yona is waiting for
No. That we have seen. So what is your prayer now? Okay. Heard Miss H.G. Barua, learned counsel for the appellant, as well as Miss A. Begum, learned APP Assam. Perused the order is the 10/3/2025. Since the response number 2 has not appeared and the conviction and sentence involves the POCSO Act, we appoint Sri Devanga Kumar Buddha 37, to act as the amicus curiae for the response number 2.
There is an IA. There is a message taken on 29th of May for the IA.
29. 29th of May. No, we'll ask matter to be listed after 2 weeks in the matter. The matter is accordingly directed to be listed after 2 weeks by reflecting the name of the amicus curiae for the respondent to who has been appointed today. Miss Mohai shall furnish copies of the relevant documents to the learned amicus within 2 working days.
Sure. Okay.
Item 10. Item 10. Yes, what is your friend?
Please like to tell the IA for suspension of sentence.
The conviction is under what? You have to press the IA. Please do. Objection is filed. What are your grounds of adequately? You have qualified by adding adequately. Now, then you have removed the qualification. Not proved. Not proved. What is the age as per the prosecution?
I would like to highlight that the entire trial is based on a faulty charge sheet. The first being there, in the charge sheet in the Caesar list, there is a birth certificate of the victim. But that birth certificate, the serial number of that said birth certificate does not match the one that has been used in court.
Where is your foundation? Which part? From where do you make the submission?
Not sure, it is,
Page? I is 1040. Which page? This will not do, madam. You have to annex the positions and this is a criminal appeal. This is not a question of pleadings. You need to place the records at least, relevant records. Where? Appeal only has got the impugned judgment. You don't file IA with some pleadings. You are insisting on pressing the IA. Press the IA. Why are you changing your stand now? Madam, it's not like that. It's not so easy. If you want to insist, if you are pressing the IA, then you come prepared. Not with an application like this. File an additional affidavit. Give all the papers from the records. You may make out a good case. We'll consider, but it's not. This is not how you assist the court. We'll not go by a statement made in the application. We'll go by the records of the criminal trial. Put the X-ray report, put the cross-examination, put those depositions. 24 matter, the records have come. We could have directed preparation of the paper. Which order? Where? Which order? Where is the order of preparation of paper book, madam? You just said. paper book, yes. What is the status? 1912. Why is it listed? You had made a mention. Three weeks time. 3 weeks. The paper book perhaps has been ready because there is an office note of 27.3, by which 3 weeks time was said to be required to prepare the paper book. That 27.3 is more than that. What is your name, madam? Or Ms. D. Dr. Lanak, counsel for the applicant. Oh, we are allowing. Ms. D. Dr. Lanak, counsel for the applicant slash appellant. Also heard Ms. A. Begum, learned APP Assam, as well as V. Prasad, learned amicus curiae for the spot number 2. Sarah? Though the application has been filed for suspension of sentence, the relevant documents and materials have not been annexed, which are sought to be relied upon by the learned counsel. The learned counsel for the applicant accordingly prays for and is granted 3 weeks time to file the aforesaid documents and materials by way of an affidavit. 2 weeks time to file the aforesaid documents and materials by way of an affidavit. List after 2 weeks. In the meantime, the office to give an updated note on the status of the preparation of the paper book. Item 11. Yes. You get your report also. For Ms. SSGL and counsel for the applicant, who submits that while the appeal was admitted on 27/11/2024, notice was issued in the IA, pursuant to which steps were taken for service of notice. Office note dated 25/4/2025 reflects that such steps were taken and notices were furnished to the learned APP. Ms. Jahan, learned APP Assam, prays for and is granted 2 weeks time both to file objection and to obtain necessary instructions on the aspect of service of notice upon the response number 2. List after 2 weeks. Where yes, first time.
The delay of 18 days.
Under POXO,
Appeal against acquittal.
appeal against acquittal.
Not under.
Third, PJ Sekia, learned counsel for the applicant who has filed this application in pursuance of first we need to condone the delay.
Yes.
And he has filed a petition for leave to appeal. Which is the delay condonation?
4 to 5.
4 to 5 million. Has filed his application under section 5 of the Limitation Act 1963 for delay of 3 days. No, but it has to go. A delay of 3 days. What is the note of the office? 3 days or what? Office also says 3 days.
Yes.
Delay of 3 days in preferring the connected appeal of the connected appeal has been filed against judgment and order that so passed by so, whereby the respondents have been acquitted. The learned counsel has also submitted that in accordance with law, criminal leave petition 17 of 2025 has been filed seeking leave. That issue notice returnable by 6 weeks. Miss Jahan, learned APP, accept notice on behalf of the state respondent. Let steps be taken for service of notice upon the respondables 2, 3, and 4 in the manner prescribed. Steps within 2 working days. Delay only on 4 to 5.
Item 13.
Yes, RKD Chaudhary. In appeal against what?
Appeal against conviction. We are seeking an answer to that.
Sentence. One application had filed earlier for in the same matter or what? Different matter.
No different.
Heard Sri RKD Chaudhary. Learned, you appear as?
Yes, Judge.
Huh?
Yes, Judge.
As Deputy GI. For the applicant who has filed the instant application under section 5 of the Limitation Act, read with section 21 within bracket 5 of the National Investigation Agency Act 2008, praying for continuation of delay of 60 days in preferring the connected appeal. Stop. The appeal has been filed against the judgment dated so and so passed by so and so, insofar as the aspect of sentence is concerned. Correct? Let notice be issued, returnable by 6 weeks. Let steps be taken in the manner prescribed for service of notice upon the 2 respondents in the manner prescribed. List after 6 weeks for service report as well as for filing of objections for my so advised.
Fourteen.
It's a also matter and it is an IS for the condemnation of 721 research.
You're An Hassan. You're also interested in music. You're also interested in music. Nadia Hassan. You're Nadia Hassan, aren't you? You know who was Nadia Hassan? You do not know. What is her brother's name? Mehdi Hassan. Oh my God. Brother's name. They are not connected to Mehdi Hassan. Heard Ms. Nadia Hassan, learned counsel for the applicant who has filed this application under section 5 of the Limitation Act 1963 for condonation of delay of 721 days in preferring the connected appeal. The appeal has been filed against so and so. Issue notice returnable by 6 weeks. Ms. A. Begum, learned APP, accept notice on behalf of the state respondent that steps be taken for service of notice upon the respondent number 2, which is to be routed through the office of the learned VP Assam. Steps within 2 working days. List after 6 weeks for service report to be obtained by Ms. Begum, the learned APP, as well as for filing objections for my so advice. Next.
15.
Mr. Chaudhary, yes.
Subject for logic and there may be two delays there. And ground mentioned that illegality and financial process. Delay will be ratio guided to budget. Ultimately, by delay, you will not get anything.
No, it depends on madam. If she is agreeing, then only. Otherwise, also we, tomorrow we definitely condone the delay, but we have to give them a chance. We'll issue a short notice after 2 weeks. Okay. Two weeks. Third. 3A Ahmed Learned Council for the applicant who has filed this application under Section 5 of the Limitation Act, paying for condonation of delay of 22 days in preferring the connected appeal. The appeal has been filed against Swinson. That notice be issued, returnable by 2 weeks. Ms. A. Begum, Learned State Council, Learned APP Assam, accepts notice on behalf of the state respondent. List after 2 weeks. List, yes, today, second. We'll have it on 19th of May. List on 19th of May. For filing of objections, comma, is advised.
16.
Criminal appeal, my lord, and they are.
You are appearing as the legal aid counsel.
Yes, my lord.
Third, Ms. D.R.A. Sultana, Learned Legal Aid Counsel, who has filed this application on behalf of the applicant under Section 5 of the Limitation Act 1963 for condoning delay of 26 days in preferring the connected criminal appeal. Full stop. The appeal has been filed against so and so and so. That notice be issued, returnable by 6 weeks. Conviction under what? POCSO, 6 weeks. Miss A. Begum, Learned APP, accept notice on behalf of the state respondent. Last steps be taken for service of notice upon the SPO number 2, which is to be routed through the office of the public prosecutor. Some steps within 2 working days. Madam, list after 6 weeks, along with service report, to be obtained by the Learned APP, as well as for filing objections, comma, if any.
I want to show clear also plan report.
What is the limitation in filing an appeal? What is the limitation in filing an appeal? No? 60 days, 90 days. How much is the limitation? How do you calculate this, that you are delayed by how many days? 94 days. How do you calculate? What is Section 5 of the Limitation Act? You have the Limitation Act. What is Section 5? You should know what is Section 5. For what? Delay may be contained where? First, you have said that 94 days delay needs to be condoned. From where do you calculate this 94 days? That is the first question. 29/6, 24. So what is the period of limitation? How do you calculate the period of limitation? Where is the certified copy? Yes, of the IA, yes. Yes, then how do you calculate the limitation? No, you have not even applied your man. How do you calculate the limitation? Aren't you interested as an advocate? You should be able to know that is it within time or without beyond the time. How do you calculate? What is the period which you get? How do you know what is there in the certified copy? Have you seen the certified copy of the judgment? Hmm? You should learn. You're attached to your senior or not? Who is your senior? Hmm? No, it's not a question of timing. You should know, you should have the interest, that much of interest. How do you calculate limitation? You take out the certified copy, when it was applied for, when did you give the stamps, when it was ready for delivery. You should know what the basics. These are the basics. Simply moving the application is not enough. What is your name? Hmm? Ekedas. Who is your senior? M. Khan. Huh? You ask your senior, how do you calculate this, the limitation? Not after some time. Part 3, Ekedas learned counsel for the applicant who has filed this application under Section 5 of the Limitation Act 1963 for condoning the delay of 94 days in preferring the connected appeal. The appeal has been preferred under so-and-so, passed by so-and-so. Para. Let notice be issued. Baki se baki, huh? 6. Respond number 2 through the office of the PP box was. Okay, 6 weeks for service report as well as to be obtained by A Begum as well as for filing of petition event. Okay.
Item 27, supplements.
I'm representing as a legal counsel here, Your Lordship. This criminal appeal jail has been filed, Your Lordship. While filing this appeal, Your Lordship, there is a delay of 89 days. So here, Your Lordship, they have given Your Lordship from Golaghat Special Judge Golaghat and Your Lordship District Legal Service Operative from Golaghat. This application has said. While sending this, Your Lordship, some relevant documents has left out. So I have to ask it again, Your Lordship.
Yes. What do you say? Yes. Heard. Miss P. Das, learned legal aid counsel for the applicant. Also heard Miss H. Jahan, learned APP, Assam, as well as Sri S. Nawaz, learned amicus curiae for the response number 2. The present application is for condonation of delay of 89 days in preferring the connected appeal. The appeal has been preferred against so-and-so, passed by so-and-so. Ms. Das, the learned legal aid counsel, has submitted that the delay has occasioned due to factors beyond her control, as certain documents which were necessary for preferring the appeal had to be transmitted from the concerned Golaghat district. In this connection, she has drawn the attention of this court to the averments made in paragraphs 5 and 6 of the application. Both Miss Faiz Jahan, the learned APP Assam, as well as Sri Nawaz, the learned amicus for the F1 number 2, have fairly submitted that since the appeal has been preferred against an order of conviction, they would rather oppose the same on merits than to oppose the aspect of delay condemnation. Clara? An application framed for condemnation of delay has to be dealt in a pragmatic and justice-oriented approach, and technicalities should and technically should make way for substantial justice. Clara? Considering the causes shown and also the nature of the appeal filed, we are of the opinion that the delay of 89 days in preferring the appeal is liable to be condoned, which we accordingly do. Clara? The I accordingly stands allowed. The appeal is directed to be registered and listed for admission after a week.
Thank you, thanks.
We have a partner, Mr. Chaudhary, Mr. Bhuyan. We have a partner, but you said that you will be pressing on the IA. We can have your matters for orders in that case. On Wednesday next or Thursday next. Because will not look good that partner matters are being left out for hearing matters. Tuesday.
Yes.
Thursday? Okay, Tuesday, when was Thursday? Okay. Though this is a series of criminal appeals has been listed for hearing, the learned counsel representing the appellants have submitted that the interlocutory applications are pending consideration. In view of the efforts of submission, we direct listing of this series for orders on Thursday next. With the thank you. On this Tuesday.
All of them is very seriously.
Yes, Mr. Mayor. Sixth on sixth.
I said number 24, my next hearing matter. Then also I will for consideration there, medical order. It's a different case. So we can have next week for orders.
Okay. You'll be pressing the IA.
Why?
Why?
Medical government. Because he was suffering from.
Have you filed anything?
I just let me be fine. So another 3 times of present.
Item number 24. Sri E. Kotoki, learned counsel. For the appellant has submitted that though this appeal has been listed for hearing, the I requires consideration as there are serious medical issues pertaining the appellant. Full stop. He accordingly pays for taking up this matter for orders. Correct? Also heard Ms. Jahan, learned APP Assam. Correct? After hearing, we direct listing of this matter for orders on Thursday next. 8th. Order.
think that, as my learned friend had said, that the conviction was only on recovery, that is a little incorrect statement because the trial court has taken other circumstances into account. That is at page 71, what you will find in the judgment. That is just pointing it out. This is not solely on recovery. Page 71, what you will get that the trial court has considered other evidence of it. Page 71 of the report. On meticulous assessment, I find more or less all of them implicated accused persons, but there is an eclipse on it. In respect of 2 and 3, to the extent of their complicity, nevertheless, all of them unambiguously stated that A1 Ajay Kuli is the prime accused who assaulted the victim. This is Niranjan Peko out of admitting. Further, the shadow of doubt has been removed by his close friend, Raju Saikya, who has stated distinctly that on the relevant day of occurrence, he was told by accused Ajay Kuli that there was a quarrel between him and some other person. On the next day, he went to the place of occurrence and saw certain blood spot nearby the house of Moni on the roadside. Later on, he came to know the injured person died. On 2nd of March, the police brought him to the magistrate court where his statement was recorded under 164. Having perused the said statement, I find it distinctly internally stated that Ajay Kuli assaulted Niranjan Peko. Further, he explicates that on the relevant day, he was accompanying the accused number 1, but due to attending his call of nature, he remained behind on the accused one proceeded again. After some time, he saw A1 assaulted someone and the victim was Niranjan Peko. The said stick was in his hand before he came to the place of occurrence. Thus, the consistencies in the prosecution evidences inspires confidence to deduce that A1 assaulted the victim and caused him the previous injuries which culminated to this death. Thereafter, he went to discuss the leading to discovery part, and thereafter he continued. So it's not a case that he did not take anything else in consideration. Now I'll go to the chain of circumstances, if it at all makes all difference. Number 1, circumstance would be, in fact, Lordship knows what the circumstances are, and that is defined here, that is explained within a case. Apart from that, I could gather one case where the Supreme Court has said that circumstances can be deduced from certain facts from other circumstances. So here I will place those circumstances which may not be substantive in nature if we take it independently. But by taking recourse to that decision, by taking help from there, I will show those circumstances which can be inferred from other circumstances or which are not substantive in nature, independent. So I go to first circumstance. Number 1, the accused, had warned one witness, PW, the Lordship will get it in page number 29. He warned I think the brother, his Bhaiti Pegu, yes, he is the brother.
PW?
PW 13. He warned the brother of deceased and told him not to allow deceased to go to select village. That is before the occurrence. If he goes, he threatened, he will kill. Lordship will find at page 29 of the paper. His son of Dasiram Pegu, he is the brother of the victim. Page number 29. Lordship did not go into the examination sheet in this first examination stage, last line. Last line. The accused Ajay Kuli warned me that he would kill my brother and not to send him to select down. So there was something which was prior to the occurrence. So what is that there was already a warning for him not to go to that place where he went and where he met his death. So first circumstance is this, where
The brother of the deceased was warned by the accused, by the convicted person, by the appellant, that the deceased should not go to that village, otherwise he'll pay. Then the second circumstance, the victim actually goes to the select village. And he also writes here he tells in his cross-examination that we have not filed any complaint before the police or magistrate regarding the threatening. I do not know personally any residents of Select-Gaon. It is not a fact that Agam Pegu tutored me to tell this or not. So he did not file any complaint, but the fact remains he was threatened. Thereafter, the victim goes to Select village in spite of the select. That lordship will get in the evidence of PW 6, 1, 4, and 13. In fact, PW 4 said that he went to Select village to pay wages to his laborers at around 5 p.m. in the afternoon. Lordship will go to PW 1 first in order to show that in fact he went to that village to make payment to the laborers. PW 1, PW no, not PW1, the father, PW2, page number 11, third line from the top. On the relevant day of occurrence, he went to give wages of the laborers and thereafter he did not return. So he went to give wages, PW2 says. PW4, lordship will see.
Now, wages, where did he go?
That is PW4. PW4 makes it more clear. PW4 says, PW6 makes it clear that it is select village. I'll come to that. PW4 also said that on the night of 25/2 at around 5 p.m., deceased went to pay wages of the laborers as he was a contractor.
Where he had gone?
Where he had got, this is in PW6's statement. The second line from top, PW6, page number 19. Informant is my father. Informant is my father, victim is my brother. I know accused person. On the day of occurrence, my victim elder brother went to Select-Gaon to make payment of the labor. It says about Select-Gaon. But here I don't know. He says that victim is my father, but the father's name is not telling with the victim's father's name. Here the father's name is stated to be Dharmeswar Pegu, whereas the father of victim is Dhanajit. While father of the victim was, the name is different, Dashinam Pegu. But he says victim is my brother. Can be a cousin brother also.
No, informant is my father.
Informant is my father, but then the name given in the
Not
chart.
be cousin.
Perhaps this is wrong. So he says that Select-Gaon, his brother goes to make payment to the laborers. PW13 also says about the same, him going to pay the laborers their money. He did not say about Select, but then he said that victim brother told him he is going to give payment to the laborers and told me that he will be coming late. That is in the evidence of PW13. So the second circumstance that the victim went to give wages to the laborers at Select-Gaon is stated or rather proved by PW6, 2, 4, and 13. They state 4 said at 5 p.m. he went, 6 said Select. Third circumstance is the quarrel. Because why I'm not going into the body recovered now, I'm going into the quarrel in order to show the chain of circumstances. Lordship will get this fact that there was a quarrel between the accused and the deceased only in the statement of PW8. So Lordship will go to page number 22, where PW8 was examined. Page number 22. The second line from the top. I was told by accused Ajay that there was a quarrel between him and some other person. So there was a quarrel between accused and some other person, which is stated to be Niranjan, which is stated to be the deceased in his 164 statement. Lordship will go to the 164 statement once of PW8. That is at page 105.
105.
And 105. It is no res intriga, it is a settled law that 164 statement can be used both for corroboration and confirmation. So here I will take this statement for corroborating that statement that there was a quarrel. Lordship will see, I was asleep at home at around 10 p.m. Ajay Kuli came and asked me to accompany him to Moni's house, saying that he needed to meet someone there. When I went with him and on the way I needed to urinate, he went ahead, leaving me behind. While I was urinating, I saw him attacking someone with stick which he had brought with him earlier. This is not the same. Next, thereafter, the man he attacked was Niranjan Pegu, whom I had not known before. After the attack, Ajay came back to me and said that he had assaulted the man back. So this statement that after the attack, Ajay came back to me and said that he had assaulted the man back. So this statement and his statement before the trial court that there was a Ajay said that there was a quarrel between him and others. Statement I checked yesterday as your lordship pointed is very different. He said that he came to know that some intruder has gone into Moni's house and said so they wanted to go to her place. Nothing different in his 160. Yes, sir, Raju said. For the third circumstances, there was a quarrel of Ajay with the deceased. Their body was found at Selector. The page now PW12, Lordship will go to page number 27. Then the body was found at Selector. Srimati Sevali type. She is the wife of PW11. And she, of course, not in so many words, but she seems to be related with Pelu, or husband is known as Pelu, or she did not know. But it was at Pelu's house that the body was recovered. And she stated that I found the person and the person came to my house. Lordship will see PW12, page number 27. I do not know the informant. On the relevant night, injured victim came to my house and told us that he sustained injuries due to accident. This accident part I'll go later. So he came to his house on a body they injured, not the body. The injured went to the house of PW12 after the incident. He was coming back and then there was a quarrel. Thereafter, he was found in the house of PW12. And this fact was substantiated by PW6, page 19. This is a topmost right, PW12. She had negated her statement before the police that there was a thunderstorm. She took the body, took the victim inside the trunk, and then she cleaned his parts and blood was coming out. And she knew him, so she called the family members and they took him to prison. Lordship will see the next paragraph of PW12. This is not these statements are not hostile statements. These statements later on we came to know from village people that Moni Dole and Ajay Kuli in collusion called the victim to Moni Dole's house and thereafter assaulted him badly, and the injured was brought from behind the house of Moni Pegu. This is not a statement which she has negated, we have said before the police. This seems to be a straight statement which can be relied on in case of hostile witnesses.
No, but the
Yes,
question is, came to know from villagers, village people.
village. Yes. Then Lordship will go, yes, this fact was substantiated by PW6.
Page
Lordship will
19,
get
page
to page
19.
19, yes, the third line. In the evening, he did not return back. But at night, I went to the place of occurrence and saw my victim brother in unconscious. He was unconscious. Then we took him to the Garapur civil, then to Jorhat, then to the. Then page PW number 13 also, Lordship will find that he was found at Select village. Lordship will get it at page 29. PW 30. Page 29, he says, third line from the top. Subsequently, at night, I heard my brother is lying in Select village in injured condition. After getting that information, I rushed to that village and the place of occurrence. And I saw my victim brother was in injured condition in the house of one Pelu. My brother was lying unconscious and unable to speak. So he was found in Select village where he went to give wages to the villagers. So his body was found at, he was found at Select. Then fifth circumstance is Moni stated before the public. Page number 15. Lordship will see page number 15, the statement of PW4. What Moni said when villagers went and saw a pool of blood behind her house. Page number 15, second line. She was an accused during that period when she made this statement. This is the statement by Agam Pegu, and he heard along with other villagers, Moni saying all this, stating all this statement. Second line, I also saw a pool of blood just behind the house of Moni Pegu and before the public. Accused Moni Pegu confessed that accused Ajay Kuli killed victim deceased. Ajay Kuli and Raju Saitya, who is PW8, forced accused Moni Dole to call the victim to their house. In the meantime, accused Ajay Kuli and Raju Saitya came to her house. And thereafter, Raju Saitya remained behind the house. This is tallying with the statement of Raju Saitya. And accused Ajay Kuli assaulted with a boloka bamboo stick on his head. And thereafter assaulted on the chest. As a result, the victim was seriously injured and became unconscious. Subsequently, he was carried by the accused person to throw it in the river. But suddenly, currently, they could not do so and finally left the victim near the house of one Pelu. And the victim deceased entered into the house of Pelu where he took his last breath. This is incorrect. He was alive then. So she stated before the public these facts. Now, how far these facts are true? That apart from these, there is no. There is a contradiction before police. But police has referred it little wrong.
No, for before on this point,
PW.
first, these statements are not made by Moni. So it's not a confession.
Not a contradiction.
It is at best can be treated to be an extrajudicial confession. So because at that time, as you have rightly pointed out, Moni was one of in the arrayed as a party, as a accused. And this, if it is an extrajudicial confession, she is trying to wriggle out of the situation. It's not inculpatory. It's exculpatory. Totally exculpatory. First, it's not a confession at all. Moni has not said. It's by somebody else, and that too exculpatory. So how far it can be relied upon to convict another person?
Yes, this is what that is why I brought the decision in order to show that it will be at best a link
Link.
in the circumstance.
Haricharan Kurmi. Which one? Moni was tried in the proceedings. She was an accomplice.
She was an.
So accomplice, so Harishan and Kurmi would come.
Yes.
30 Reddit
Like,
30 Reddit 114 illustration G.
yes.
Illustration B.
That can come. And of course, this is one of the state link in the circumstance that she said these things are. But PW 14, there is a contradiction as far as these statements are concerned. He referred the number of the PW as PW 5, but then the statement relates to PW 4. Lordship will go to page number 32. The contradiction that has come. Page number 32, cross-examination of the IO. Page number 32, cross-examination. 4-5 lines from the top. After
32.
after 1, 2, 3, 4, after fifth line from the top in cross-examination. PW 5 did not state in his 161 statement that Ajay Puri assaulted the victim. This should have been PW 4. Victim with bamboo stick behind the house of Moni Dole, and the accused person tried to dispose of the dead body but could not do so as electricity came. PW 5 also did not state before me that Puli dropped the victim deceased in the house of Pelu. This much. These statements relate to PW 4. He had perhaps wrongly stated as PW 5. So, some part is contradictory.
No, this contradiction is so far as the statement made by PW 4 in his 161.
Yes.
So, and this just now which you have read out is PW 4. That current had come. They initially planned to throw the body in the river. Current came. They abandoned. Then he had gone to the house of this Pelu. Yes.
But then here he did not say that he heard it from Moni. It is almost like Ajay Puli had straight up his told from, as he has said. But then in the trial court, he said he heard it from Moni. So, neither as I agree, but what we can deduce here from that some statement was made by Moni before public, which PW4 had known. Thereafter, the straight statement, Lordship will have seen PW12 statement that here's the part that they had killed them if she was small and all. This corroborates the Moni statement. The statement made by PW12, although that's a hearsay. Then the pool of blood was found behind the house of Moni. That is the seventh circumstance. Blood pool found behind Moni's house. That is stated by PW5, page number 70. Statement also shows that the blood was not exactly near the house, it was little away at the backside of the house. PW5, page number 17, he says, is at page 70 by PW5. The previous page. Last but 4 lines. We have also seen some blood stain in the house of accused Momata Pego, which was cleaned with water. But this is another circumstance that comes in favor of the prosecution. That the blood was, there is an endeavor to conceal it. Thereafter, this next circumstance, a stick was recovered. Now, how far that Caesar list will be applicable, that I have a judgment to bank on. Here, the stick was recovered was stated by PW4, page number 50. Because he said that the object to be another provisional reverse.
Where is it?
Stick recovered, PW4, page number 50. Bamboo stick on his head and then he tried to was seriously subsequently he was carried. PW5. Oh, yes. PW5, page 17.
Not 4.
PW5, page 74, I have please allow. PW5, page 17, Logic had already seen yesterday that bamboo stick was recovered by the police from backyard of the house of Momata Pego's house. So 5 said that there was a stick which was found from the backyard of Momata Pego's house. And then PW14, page number 31. PW14, the police said.
Page 31.
Page 31. I seized one bamboo stick being led to the discovery, on being led to discovery by Ajay Kumar.
Where is it?
This is at 6-7 lines from the top. I proceeded to the PO again, from where I had seized one bamboo stick. After CD,
Yes, yes.
yes, this is where he had recovered the bamboo stick. The stick was recovered from the place of occurrence, that is behind the house of Pelu or Momata Pego. Then the next circumstance is bike recovered. Bike was recovered near the house of the appellant. This is stated by PW9, page 20. PW9, page 20. PW6, no? PW6, page 20. PW6, so you can see in his cross-examination, 5th line from the top, 4th line also. My brother was coming from home in a bike in order to make payments. The bike was recovered near the house of accused Ajay Kuli. That's it. The bike was recovered near the house of accused Ajay Kuli. So the bike was recovered was also stated by PW4, page number 50.
15.
Yes, 50. The last line. Page number 15, last line.
PW?
For PW4, page 15, last line. The bike of the deceased was found near the house of the accused Ajay Kuli in the school field. The bike was recovered from Ajay Kuli's house. Then the mobile phone of deceased was recovered from the backside of Moni's house. That was stated by PW5. But then again, there is some doubt as far as the place of recovery is concerned. By seeing the Caesar list, that doubt comes. Lordship will first see page number 17, the last page, last line. Not last line, fourth line from the top. We also recovered the mobile phone of the victim deceased behind her house. Victim's mobile phone was recovered behind the house of Mohammed Singh. But then if the Lordship goes to the Caesar list, it seems what the police wrote, the mobile was seized from the accused. Now, whether he talks of the same mobile, that is also not clear. At page 95, the Caesar list is there. Same phone, but then they talks about a mobile phone. The police writes in the Caesar list, noted article from the possession of the accused Ajay Kuli in connection with so-and-so case that was seized on 2nd of March. Place of Caesar is PS, one blue colored Android mobile phone number so-and-so. Now, there is nowhere in the evidence to link these two phones or whether these two phones are the same one. But the fact remains PW5 said victim's mobile phone was found behind the house of Mohammed. There is another. The judgment at page number 79, that mobile phone was returned back to the victim. Victim's family, I mean. 79, 79, 79, 79 second paragraph. The seized motorcycle bearing so-and-so and mobile phone number so-and-so and EMI RME, so shall be given to the nearest kin to the victim and the seized bamboo stick shall be destroyed. So this phone is of the victims. But then in that case, from where it is recovered, that will be done. Motive is important in circumstantial evidence. So motive is writ large, Lordship had seen, PW4, page number 1450. The motive has come into picture that Ajay Kuli and the deceased had some relationship with Moni Dole. And so there was a strained relationship between deceased and the accused. As well as some monetary transaction that of course is not linked to the issue. Here the relationship which he again reiterated in his cross-examination, that at somebody's funeral, both Niranjan and Ajay Kuli wanted to take money to them. So there was some relationship, some strained relationship between accused and the deceased. So there can be a motive for this. And then the next is homicidal head injury, which is it corroborates the statement of PW4, who stated that Moni told that the hit was on the head. Parietal bone, temporal bone, they are all fractured, they are all broken. So the death, the homicidal death, which is found by the doctor in his report, corroborates the statement of PW4. And the other one.
No, the ones you say homicidal. Homicide means what? Killing of one person by another person. The culpability aspect is different. Now the accidental aspect is also here. Accidental death is not a homicidal death. So there are at least two witnesses who have said that he, in fact, at the dying declaration, had said that I met with an accident.
But then what I will say is, one of the witnesses at page 29, he said that I reached after half an hour of the incident. He was not in a position to speak because these are oral dying declarations. Oral dying declarations, because Supreme Court has said we need corroboration. These two are oral dying declarations without being
No, the
corroborated.
oral declaration per se is not inadmissible.
Ah.
Everything will depend on the facts and circumstances. There may be a state where it's not possible to record the statement.
Yes.
Last
and-
stage, he says something. Can you discard it? It will all depend on the veracity of the witness who.
Corroboration is required. So here I don't find any corroboration, rather 29 at page 29 PW 13 had said that he reached. half an
Where are
hour
the
late.
decisions, where there are decisions on this side also? When the illustration on 32 says evidence, it's a relevant piece of evidence. If it relates to the death. Yes, corroboration as a matter of prudence, yes, in every case.
But in
But-
case of
But
oral, not-
if the draft ordinance is not doubted on the witness before whom such dying declaration has been made, it can be the basis of a conviction.
this is a dying declaration not made for Dr. Maester and all.
Not required, not required.
Oral.
Now, where is the requirement that you have to make a dying declaration before a magistrate or a doctor?
May not be.
It may not be recorded also. It can be an oral dying declaration. Let us see the definition.
32.
32. 32A, I think. 32(1), yes. When the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of the person's death comes into question. Now, there are many cases, many decisions that the dying man is.
He's not expected to lie on those things or always there. It can be the sole basis of conviction is there, but this is oral. And I would say some corroboration is required, which is not there in the facts of the case. And plus, page number 29, Lordship will see, my brother was lying unconscious and unable to speak. So whether
Page.
page number 29, this is the statement of PW 13, the brother. Page 13. After getting the information, fourth line from top, Lordship will see. After getting that information, I rushed to that village and place of occurrence, and I saw my brother was in injured condition in the house of one Peru. My brother was lying unconscious and unable to speak. So in that case, whether, of course, before that, he could have said that can be a possibility. But when he reached, he had not seen his brother being able to speak. It's what I find it that
Just a minute. Please. See this 26, at page 26, PW 11. Vineshwar died.
Husband of.
Vineshwar died. He says, I know the accused person, the dog. I saw the deceased with injuries and blood on various parts of his body. I immediately informed the village people and of the injured person, and they came and took him away. How that was caused, I do not know. In cross, he says that victim told me that he sustained due to accident. Now, we take this not what has fallen from him, but we just test it with the other. See, he appears to be a person of the same village where the injury had taken place either by the assault or by accident. So far as PW 13 is concerned, who is the brother of the deceased, he stays in another village.
Yes.
He got the information, he came to the village from his village to the place of occurrence and found the injured in an injured condition and not in a position to speak because he was unconscious. So the proximity, regarding the time of PW 13 reaching the place of occurrence and PW 11 reaching the place of occurrence, there is a difference. And
In his cross-examination, PW 13 has stated after half an hour each.
half an hour. And this thing that victim told him had come in the cross-examination.
And he is supposed to be a Pelu, I think, husband of PW 12. In his house, victim reached first.
Vineshwar died.
Husband of PW 12, who turned hostile. It is in their house when the deceased reached first. So it can be a case the deceased went and immediately stated to them.
And interestingly, the PW1, the father,
Dr. Pelu is reflected in the chart sheet as my Hernet Prentice pointed out.
Vineshwar,
Page number 101. Vineshwar is Pelu.
that you are only indicating. And now you come to the informants deposition as PW2 at page 12. Accident in his cross examination. Yes. 12.
So now we have to balance whether it's a case of accident. While coming back, he met with an accident and he died. Went to Pelu's house.
No, madam. If simply by stating in the Ejahar that it was an accident, will not rule out the probability of the matter being the death being a culpable homicide. That he has whatever he had come to his knowledge, he just informed the police. Now, accidental case on information on investigation is found to be a murder also. The only thing is that there has to be sufficient materials to come to that conclusion.
He was having relationship with a married lady. Perhaps at the first point of time, he said about accident, he did not say I went to her house. She was a married lady, mommy. In order to hide that fact, he might have also said about accident. That can be a possibility. There was a fight between these two persons over relationship with a married lady. Otherwise, 164 statement of Raju cannot be also brushed aside. There was a quarrel and all. Had it been an accident, the quarrel aspect would not have come at all. And then another part in Moni's statement, there is another part where he said to save Raju. Raju also prayed before her to save him. That part is also there. So it's not a case of accident per se, but I can say because of so many circumstances also. He might have said about accident. He was taken to the hospital. Next day he died. It's not an instantaneous death. He might not have thought that I will die. He had written the facts.
But in the cross-examination, the PWT2 says, leave aside the information, the Jahar, 26 to 2022. After coming to know of all the facts, he is still insisting that he heard about the incident as a matter of motorcycle accident at page 12.
See, PW12 was of the father. And PW12 was stated by the deceased that it was an accident. So 12 had stated to the father that it was an accident. So father wrote. Father came to know from PW12 and 13. To whom the deceased said about the accident fact. So the father said, apart from 11, 13 and father, nobody had said about accident.
Now, from where do you get that 11 told, inform the father?
Because 12 said in her, of course, in her hostile part, that we inform the family members. 12, Lordship will see. In her hostile part,
Yes, hostile at page 27, 28.
27,
Yes.
and being identified the victim person, we informed the family members who came subsequently to their house and took away him for treatment.
Where is it?
That is the hostile part, page number 27, last part, 2 paragraphs. In this hostile part, last line.
Yes, later on, we came to know.
No,
From
no,
the-
before that, it is the hostile part, not the story.
Yes,
There was profuse blood from his body. Lordship got it.
yes.
And being identified the victim person, we informed their family members who came subsequently to our house and took him away for them. So brother, father, everybody was informed by these people, 11, 12. 11 is Pelu. Consensus in my humble submission, I'll go to the judgments.
Where is the IO?
IO is 14. 27 recovery, I'm not pressing my arguments on. Because the stick was lying for so many days in the open area. To everybody's vision, to everybody's, everyone could see it. So it cannot be a 27 recovery, because 27 recovery is very difficult to do. We have to prove each and every ingredients of it. 27 recovery, I'm not going, only when the stick is recovered will be a link. Police is PW 14. Not a very long statement.
Yes, which one? Next, what?
Judgments are like this. These are the circumstances.
Yes, yes.
Judgment, first judgment, this is 164 can be used for both corroboration and contradiction in order to support that foreign part I'm placing that judgment. This is 2013-14 SCC. 2013-14 SCC. 266. 13-14 SCC 266.
Para?
Paragraph 13 and 16. What you can see is written now. That 164 can be used both for corroboration and contradiction. Paragraph 13 and 16. It also says the same.
Where, madam? Where? I think the paragraphs are different.
13 is,
How does 13 starts? I
oh,
think,
they have taken it up.
I think you are reading Supreme.
I'm reading Supreme.
The paragraphs are not matching. It's not 13 and 16. Be different. How does it start? No, it is R. Sazi.
Arsha. This is, 13 starts with, clause 4
No,
of
no,
section
no,
207.
that is what we are wondering.
Oh, acha, acha. That is a, there is a subparagraph, a
No,
reading of the judgment of the court.
no, you said the paragraph. We have made the direction only those paragraphs paper needs to be taken out to save paper. Otherwise, whole judgment is not required. We have the judgment in the
Acha, acha. Maybe entire judgment, he took taken that judgment. Or he took it out from SSC. Otherwise, I mailed the entire judgment to take off the paragraphs.
Is it there?
It's there indeed. I
Maybe
mailed the
also-
entire one.
Then to say paragraph 2 like the first page to the this paragraph to the
That a shadi. Oh, yes, sir. Page the paragraph 13 and 16 of my judgment. Not the same thing.
Sazi, R. Sazi.
Partial. The judgment that I had made. Non other journals, the paragraphs are always different. Only in SSC online, the paragraph studies with the books. I'll read out slowly, Lord. A reading of the judgment of the court below shows that both sides refer to so and so. It is well said that the statement under 164 can be used both for corroboration and contradiction of the author of the judgment, and thus we did not find this ground for word acceptance. Then paragraph 16 also says, paragraph 16, 157 of Evidence Act makes it clear that the statement recorded under 164 can be relied upon for the purpose of corroborating statements made by the witness in the committal court or even to contradict the same. So only for that purpose, the foreign part, which he had stated in his 164 and he stated before the trial court, and both corroborates each other. I mean, 164 corroborates the other. Then the other paragraphs will also not tell you. Yes, it's all right.
Yes, yes.
Then circumstantial evidence that I said that even inference can be drawn from the circumstances. That is 2010 HSCC 593. 2010 HSCC 593. Paragraph 11 in Supreme today. Paragraph 11.
Will be different.
Will be different.
Importance.
Paragraph 11 I'll read out slowly.
Inference can be drawn.
I'll just read out. On the other hand, circumstantial evidence is evidence of relevant facts which one can by process of intuitive reasoning infer about existence of facts in issue or factum probenda. In dealing with circumstantial evidence, there is always a danger that conjecture or suspicion lingers the mind may take place of proof. Suspicion, however strong, cannot be allowed to take place of proof, and therefore the court has to be watchful and ensure that conjectures and surmises do not take place of legal proof. However, it is not derogation of evidence to say that it is circumstantial. Human agency may be faulty in expressing picturization of actual incident, but the circumstances cannot say. Therefore, many a times it
What is the name of the case?
Name of the case is this is G Parsh Parsh WANATH Parshwanath.
G. Parshwanath.
G Parshwanath versus State of Karnataka. But then we state that the paragraphs will not tell you, look for this.
না, তেওঁৰ নিউজৰ পৰা সেইটো ওলাব লাগিব
Online paragraphs will
মানে তেওঁৰ মেইলটোৰ পৰা দিব লাগিব এইটো নহব SCC paragraph or what? No, Supreme Court paragraph.
Diamond I wanted to stress on is each fact sought to be relied upon must be proved individually. That is okay. However, in applying this principle, a distinction must be made between facts called primary or basic on one hand and inference of facts to be drawn from them on the other. In regard to proof of primary facts, the court has to judge the evidence and decide whether that evidence proves a particular fact. And if that fact is proved, the question whether Lordship got a kind of level.
Yes.
Lordship has got it. The middle part, Lordship can see.
In drawing.
Yes. I have also read the third line of paragraph 11, circumstantial
Yes.
evidence is originally inferring from the existence of facts, initial and factum probata. Then Lordship can skip few lines, then suspicion and conjectures, Lordship moves. In cases where evidence is of a circumstantial nature, the circumstance from which the conclusion of guilt is to be drawn should in the first instance be fully established. This is what even 84 says. Although there should not be, however, each fact sought to be relied upon must be proved individually. However, in applying this principle, a distinction must be made between facts called primary or basic on one hand and inference of facts to be drawn from them on the other. In regard to proof of primary facts, the court has to judge the evidence and decide whether that evidence proves a particular fact. And if that fact is proved, the question whether that fact leads to an inference of guilt of the accused person should be considered. In dealing with this aspect of the problem, the doctrine of benefit of doubt applies. Although there should not be any missing link, yet it is not essential that each of the links must appear on the surface of the evidence adduced, and some of these links may have to be inferred from proof facts. In drawing these inferences, the court must have regard to the common course of natural events and to human conduct and their relation to the fact of the particular case. The court therefore has to consider the effect of proof facts in deciding the sufficiency of circumstantial evidence for the purpose of conviction. The court has to consider the total cumulative effect of all the proof facts, each one of which reinforces the collection of guilt. And if the combined effect of all these facts taken together is conclusive in establishing the guilt of the accused, the conviction will be justified, even though it may be that one or more of these facts by themselves are not decisive. The facts established should be consistent only with the hypothesis of the guilt of the accused and should exclude every hypothesis except the one sought to be proved. But this does not mean that before the prosecution can succeed in a case resting upon circumstantial evidence alone, it must exclude each and every hypothesis suggested by the accused, however extravagant and fanciful it might be. There must be a chain of evidence so complete so as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, as must show that in all human probability the act must have been done by the accused, where various links which are in themselves complete, then the false plea of false defense may be called. So here what I wanted to press on is that inference from certain facts can be drawn. Next is on Caesar is not proved by witnesses. Of course, I could not get that direct decision. But the two decision I placed 9611 SCC 685. 9611 SCC 685. If it is not proved by witnesses. There are six. Paragraph 6, what you can see.
Yes.
Paragraph 6. Having gone through the record, we it's a small judgment, paragraph 6. We find not substance in each of the above. Before conducting a search, the concerned police officer is required to call upon some independent and respectable people of the locality to witness the search. In a given case, it so happen that no such person is available, or even if available is not willing to be a party. It may also be that joining the search, such party may later turn hostile. In any of these eventualities, the evidence of police officers who conducted the search cannot be disbelieved solely on the ground that no independent and respectable witnesses were examined to prove the search, but if it is found, as in the present case, that no attempt was even made, then in so and so cases. So if nobody comes or people come
No,
outside,
if there were no Caesar witness at all, matter would have been different. Here we find the signatures of two persons. Caesar, one has come, has said that no, he has not signed. The other one is a different person who has also disowned.
another one is not there. No, here there is one more line. If somebody turns hostile also,
There also it can be. But here not.
No, direct. The second case, what you can see, 2011 SCC. 2011 SCC.
Yes.
2011. Yes. 2011 SCC. Paragraph is 24. In Madan Singh versus State of Rajasthan,
2011 SCC page.
111. Paragraph 24. Okay, there a different case was referred. In Madan Singh,
Yes.
it was observed that where the evidence of the investigating officer who recovered the material object is convincing, the evidence as to recovery need not be rejected on the ground that Caesar witnesses did not support the prosecution work. That means Caesar witness did not prove. So even then, if it is convincing, it can be relied on. If subject knows not recovery of weapon, no, not sending it to serological test, will also not be treated as that. That of course is judgment, a very recent judgment by Justice Ujjwal Punia is there. But you can see once 2024 4 SCC, very new judgment. 2024 4 SCC 208. That is paragraph 29. Thus, what can be deduced from the above is that by itself, non-recovery of the weapon of crime, if the weapon would not be fatal. When there is such non-recovery, there would be no question of linking and all. Obtaining of ballistic report and examination of ballistic expert is again not an inflexible rule. It is not that in each and every case, the death of victim is due to gunshot and all. This is a gunshot case. Then expert will have to be examined. Or omission to obtain ballistic report or non-examination of ballistic expert may not be fatal if the evidence tendered are otherwise regarded. This is only for the aspect that such things are not always fatal. If I have other evidence of report. Then these are all Caesar not proved by the witnesses and non-recovery of weapon. And two more judgments, very small judgment. Govardhan versus State. This is a long judgment, paragraph 17. Govardhan, this is not a Supreme Court judgment, this is a Chhattisgarh judgment. Paragraph 71.
Not so, this is Supreme Court.
No, this is Chhattisgarh. They write it in that.
No, but the name of the judges have been written. It's a three judges bench. This is Gawai.
Oh, yeah, Justice Gawai, this is. What this is Chhattisgarh, this is Supreme Court, stand correct. Citations are available.
No, you have the INSC,
Ah,
that INSC
yes,
47.
there,
Which one?
1771.
Non-recovery.
70 is, it is now well settled that non-recovery of weapon of crime is not taken to the prosecution case and it's not signed for it. And then, this is on non-recovery, actually, it was not recovered. Then 71 also. In this context, we may refer to the decision of so-and-so where it is observed that testimony of police personnel involved in recovery of articles need not be disbelieved, and the testimony of police personnel is to be treated similar as testimony of any other witnesses. But here only the police says, then what you can, in the facts and circumstances can be. And the last judgment that I wanted to place is 2005-7 SCC 408.
Okay,
This is the last one.
then we'll have to,
Paragraph 13 occupancy is not relevant. It was also pointed out by learned counsel for the respondent that no firearms were recovered, no seizure has been made. It would have been better if this was done, and it would have corroborated the prosecution story. Seizure of firearms, recovery of guns, sending them for examination of ballistic expert. This I am referring only to meet the argument of my friend that it was not sent for ballistic or for FSL examination. But here it is said that not sending them for examination by ballistic would have corroborated the prosecution case, but not sending them to ballistic expert in the present case is not better in view of the categorical testimony of the above incident. So when there are enough circumstances, not sending will not be of this.
we'll come back. We'll
Yes.
hear you for some time. Then if you, Mr. Pai wants to give some rejoinder, if at all. But make it faster.
Three logic I think.
Well,
Three logic
no, three, we have division bench. No, we'll finish it before that. We want to give a date in your case, so that matter becomes certain. Otherwise, again, notice might have to be given by the trial court for your appearance. We'll give a date when both the parties will appear before the trial court. From that date, the trial court will take charge. Okay, we just indicated. Kindly inform me, probably 26. After rising, you meet us.
The entire particular facts, the
Here for R2, you are a regular counsel. Yes, please.
The 164 statement can be used to corroborate the statement of the witnesses, other witnesses. Like we have already seen in the 164 statement
Of
of Raju at page 105.
Yes.
This last one says, while I was urinating, I saw him attacking someone with a stick, which he had brought with him earlier.
Which one? I saw him. Yes, yes. Yes, yes. I saw him.
Continues to answer.
Yes, yes.
I saw him attacking someone with a stick, which he had brought with him earlier. I have watched him. Already yesterday had been discussed that probably the Caesar list where the bamboo was seized, that is not admissible. But your lordship, if we go back to the deposition of PW4, he has also said that the victim was attacked with a stick. Also, if we see the Caesar list, your lordship, the size, though we are not on the admissibility right now, but your lordship, if we look at the size of the bamboo, it was around 2 feet and 5 centimeters in thickness. Your lordship, that is also enough to cause the wound, which has.
No,
been-
the conviction and sentence is based on the Caesar list. Caesar list per se does not appear to be a valid piece of evidence. It's not been proved. We are not saying that the other evidence would be discarded, but to come to a conclusion of conviction based on the other materials, those have to be such materials that it can be trusted, it can be given credence, and it can be legal evidence. Take us to the evidence of PW4 which you wanted to.
Your lordship, yesterday only.
No, you said PW4 had said something about this stick, isn't it?
Yes, your lordship, just that. At page number 15, which has been repeated over and over again. It's just eight lines from the top.
No, the main, if you come to PW4, the ultimate question which would be put to you either by the court or from the circumstance is his statement in the cross-examination that he was in his residence, which is at a distance of 4 kilometers. So the deposition which he had given of the assault allegedly made by his client using a stick are all based on something which you have heard. So once it is hearsay, it is no evidence. Hearsay is no evidence. Evidence may be direct or indirect, but hearsay is no evidence.
So then we go to PW11.
11.
Yes, PW11 and 12. Page 26. So this also we have gone over, where this victim was supposed to have been found, as they have already said. This witness says, I do not know the informant, I know the accused persons present in the dock. I saw the deceased with injuries and blood on various parts of the body. Now we do not know if was he lying down, in what condition he was. But if we come to PW12, she again says that on the relevant night, the injured victim came to my house and told us that he sustained injuries due to the accident. It's a lordship. But, however, if we go back to PW4, as this is hearsay, but however, your lordship, just the story. If we go back, he said at page number 15 that subsequently he was carried by the accused persons to throw in the river, but suddenly current came and they could not do so, and finally left the victim near the house of one Kedu, and the victim deceased entered into the house of Kedu where he took his last breath. Now, your lordship, this evidence, this deposition by PW12 is supported by this portion. Why I'm saying this? Because even if we assume that it was a motorcycle accident, there was no motorcycle recovered at the place of occurrence, first of all.
Motorcycle was recovered.
No, your lordship, it was not there, which is said the bike of the deceased was found near the house of the accused.
Yes.
And if we look at the sketch map, the accused Ajay Puli's house is nowhere in that sketch map, the place of occurrence. If your lordship just goes to the sketch map.
Yes.
89. Your lordship, we find all the houses, but we don't find the house of Ajay Puli.
Yes.
Ultimately, is nowhere in the cell, not in the vicinity.
You see the scissor list. Your submission may not be correct.
Yes, Your Lordship.
Come to from not house. From the brother. He had already taken position. It was neither found in the place of occurrence nor anywhere on the road. You kindly come to the scissor list, page 93.
Yes, Your Lordship.
Please read. Please read. Please read.
PS district margin. Who hereby sees the below descriptive articles in connection with above reference from the convention of or on being produced by Shri Bhaipetu, son of Basiram Petu of Malapeta Gav. PS Verma district margin in connection with above reference in presence of undersigned business.
Yes.
Date of Caesar, so and so. Yes.
And this Malabindha is the residence, the place where the informant and the brother used to stay.
Yes, sir.
So the motorcycle recovery will not neither be here nor there.
Only this one. If we look at the address of the PW, your Lordship will see
Page, madam.
page 26 and 27,
Yes.
where this victim was supposed to be found.
Varamur.
Yes, your Lordship.
No, house is
House
at
is one-
Nalduar. Nalduar.
Yes, sir.
It is not select. Select now. House is in Nalduar. And there are evidence on record that the brother, on being informed, had gone to the place of Bineshwar or Pelu, and thereafter had recovered the injured brother, and thereafter taken him to the hospital. So it is from the house of Pelu, that is, I think, Bineshwar, which has been clarified, from where the injured brother was recovered.
Your Lordship, if this person was so injured, where he was not in the position to get up and walk, why it would, I do not know the distance, I tried to find it out, how far Nandua is from Salem. But the question being that is why wouldn't he go to a house which is, if it is a case of accident, why wouldn't he try to keep the closest house in the vicinity? And why would he go some place?
No, as
which
per
is-
you, as per you, where was the accident?
Your Lordship, whatever I can see in the sketch map, the place of occurrence there, everyone saying it's select.
No, a place of occurrence is recovery of the brother. What is,
Yes, sir.
so what is the place of occurrence?
It is the house of money, money is the place of occurrence. And here was it, where the bamboo stick and that stick was supposed to be found.
Sketch map was that page? Sketch map was that page?
89.
Morning. This may be even damaging. If the place of occurrence is at Monish Dole's house, where blood stains were found, But as you had said, it is on record from the prosecution case that injured state brother was found in the house of Telu. Telu's house is in the vicinity, doesn't appear to be.
There is no Nobokanta Type's house, but Type is surname is telling with PW. Moment, because that is-
This Moni Dole, her address, what is her address?
This is in a 330 select.
Select. But this person, Telu, says this is Nonduar. Telu and his wife, both.
Continuous.
But if he's assaulted in such a manner that he, within a very short duration, he passes away, is it possible for him to, what, he had to be carried. He was not in a position. He was unconscious even, in fact, as per a brother. How could he come to the house of Pelu? At least Pelu's house is not shown in the sketch map. That's not in the immediate vicinity. Maybe around 100 meters or 50 meters. So 50 meters is also a big distance for somebody who's injured to that extent. Either by accident or by assault, whatever. What was the kind of, Madam Rao, what is the assault? What is the medical evidence?
Fracture and nervous
On the head.
on the head. Fracture 107.
107. Yes, please. Linear fracture, left temporal, linear fracture, both parietal, parietal. Now, first is lacerated is okay, lacerated wound. But there is a fracture, two fractures. Abrasion is okay over the nose. Linear fracture of length 3 centimeter on the left temporal bone. Linear fracture of length 9 centimeter of both the parietal bones.
It says that the lacerated wound of length 9 centimeters is capable of getting a person unconscious, and also it may even affect or impair the speech of the person. So,
Lacerated, 9
yes.
centimeter.
Happens.
Cut wound,
Yes,
9
the
centimeter. 9 cm. Blunt impact lacerated wound of 9 centimeter. Final opinion is caused by blunt impact. Blunt impact would cause lacerated wound.
Often characterized by ragged or irregular edges and is typically caused by blunt trauma or tear. That can be caused by the Holuka engine. It's a function, which is why I was just reading that.
Laceration doesn't need a sharp weapon.
So
Okay. The doctor,
Yes, sir. In the first examination, this conflict and the first examination. This is the logic to be followed.
yes,
Such kind of injury may result from an accident from a motorcycle and taking a course. I did not find any sign of consuming alcohol that is. The Lakshya, the council yesterday mentioned that it could be that because in the sketch map, if you can see there's a concrete post, which was also brought out in the cross examination of some witnesses. But in the sketch map, again, I go back to that, page 89. If we see, we can see that there's a row of trees there. And there's a row of trees there.
Hmm.
And there's no motorable road there. So now again, this becomes very doubtful. That why would the victim take that road when there's no road? And the concrete pillars are behind the house of Modi Gole. And even if assuming that there is a motorcycle accident and this person must have been flung over and he hit the concrete post. But why would he take a road which is not motorable? And it's leading to nowhere.
why do sketch maps, madam? First was the 26/2, the date of lodging of the Ejahar. And the second was the 2/3. No, one thing is certain that only because certain concrete pillars are there, it will not lead to the only conclusion that there was an accident, he fell in the concrete pillar and he got injured. He can be brought there and also assaulted. Finding him in the near the concrete pillar doesn't necessarily lead to an inference of an accident. That part is okay. But what about the informant may not know, he's a hearsay about the accident at the time of lodging of the Ejahar. But as a witness, in the cross-examination, he said that it happened as an accident. And the two persons before whom the dying declaration was made, both of them, Pelu and his wife, has said that this deceased has told us that he met with an accident.
But the question remains, how do you?
No, that is your case. The prosecution's case, that he was recovered from Pelu's house. Yes. He was recovered in Pelu's house. Pelu said that yes, he told us about an accident.
And when I went to PW 12,
PW4 said he was carried. PW4 Agam is a very important crucial witness, but the statements which he had made were all heard heard by him. Raju Saikya confession would have been a material aspect, but Raju Saikya has been acquitted. The accused Raju Saikya confessed before me.
It's not in charge.
He was not even charged. Who was the charged person? Raju was not there. Moni and Ram?
Ramki is the brother of Ajay.
And who is this Raju Saikya Pegu?
Actually, accompanied with
Oh, he's PW8
164.
of 164. Then how do you reconcile PW8 and PW4? PW4, the complicity which the PW4 alleges upon the present appellant, almost more than that, the allegation is more on Raju Saikya. And Raju has confessed before him. Okay. Yes, anything else, madam?
So if it's not murder, like, the number comes right to the scenario, that could be absent. But the thing is that the fingers have been pointed towards the appellant himself, because everyone votes yes, I understand. But the thing
No,
is-
madam, we cannot go by emotions. Person has died, but it has to be proved in accordance with law.
Yes,
Even suspicion cannot take the place of legal proof.
yes,
You can prove it either by direct evidence or by indirect evidence, which is circumstantial in nature. It has to inevitably lead to only one conclusion. And there should not be any inconsistencies.
yes, Your Worship. So
Person has definitely died. We are aware of that. But we need something more than that. Not something more, much more than that. That it is the appellant who is the person who had caused the death.
Yes, Your Worship. And even if we try to bring in the scenario that it's a case of accident and no one is involved in it. But even those things they're not being able to bring out from the Worship.
No, he is not required to prove that it is accident. He is just required to say that I am innocent.
Simply create doubt.
Doubt, that is a reasonable doubt, not fanciful doubt, not imagination, not surmises.
Yes, Your Worship, which is why I just came to that point where this person, since the place of occurrence should have knowledge of this house. Everyone said that there was blood stains and all of this thing. So just one question that came to my mind is, how did this person who was not in the condition of even standing up, how could he have reached to a place which is not in the vicinity of the place of occurrence? At the most, even if he was hurt in an accident, he would go to the closest house that is located there. Why would he go so far? I do not know the distance also, Your Worship. I tried to find that, I couldn't. But that is one question that came to mind.
No, this question would be better if it comes from their side. You are trying to defend the conviction.
No, Your I'm not trying to defend the conviction, it's only because the learner.
No, you are for the victim, aren't you? You want justice, you want justice to be done. Justice is he is the perpetrator of the offense, he needs to be punished in accordance with law.
Yes, sir. That
So
is not-
it's this question which you are raising would only bring another aspect of doubt of how, if that was the place of occurrence, how did he reach here in that state of health? This person says that he said that it was an accident. Immediately he became unconscious. We do not know the distance.
Yes, sir, but
It should have been brought to record. This is the distance from the place of occurrence to Moni's house. Nowhere.
yes, sir, but yeah, I understand. And all I was saying, I was relying on PW4, and this is hearsay, I understand. But the thing is that there was no one apart from Raju Saikia who had, that also we do not know if he was or not.
He
But
wasn't
in his
there.
164 statement, he had said it, and which was right after the incident. And why, again, why would a person say that he was at the place of occurrence and he has seen a certain incident if he wasn't there? That's a different thing that he resigned later.
Okay. Who has proved this 164? P8? No, the exhibit P8. Who has proved? Oh, re-examination. Okay. Raju as such has not denied he is making a 164. In fact, in his re-examination, he reiterates that his statement was indeed recorded. And pre-recorded statement as per 157, I think, of the Indian Evidence Act. No. What is that section 154? No, 157. No, not re-examination, pre-recorded statement. Looking 157. No, not 161. Evidence Act. 157. Yes, 157. Former statements of witness may be proved to corroborate later statement as to the same fact. In order to corroborate the testimony of a witness, any former statement made by such relating to the same fact or at the same time or before so and so, the fact may be proved.
Government also provides the same one, which is a advance based on 164 charging.
Okay. Okay. That's all. Yes. Anything? Judgment or what? Hurry up. 5 minutes.
What is pointed out, which is beneficial for me. The place of occurrence is not in court. The entire proceeding place of occurrence is not. Because as it has emanated from the evidence, now there are two places of occurrence. Which, in fact, the place of occurrence is not there. Right. So, in fact, the evidence shows that there are two places of occurrence. So, unless it is closed, place of occurrence is very difficult. So that has to be proved. That is not true. And second matter, which in fact only one evidence I'd like to clients of this authority and this mother Monica and the bikes status. Probably.
Madam, you have your seat.
PW eight in this.
Madam Brown, have your seat.
Yes. PW eight, mother. Page 22.
PW 8, yes, page 22.
Mother, last with regard to place of occurrence, mother, here six. With regard to the mother, the blood spot. I have not cross part, mother. I have not seen the occurrence. Blood spot was about 200 meters away from the house of accused mother, accused money. So, and PW 6 is 20 mother. Cross part, mother. What do you say? This is mother the
Page,
yes, page 20 mother.
20.
Yes, Anil Pegu, the brother who is one of the crucial test mother. What he has said with regard to recovery of bike, this mother. Campus raising a question on that mother. The bike was recovered near the house of accused authority. Mother, in fact, it similarly shows it was recovered from the person, mother brother. From the person. From the brother of this mother, Anil Pegu only. The house of the accused Monidol is located between two tree houses of both sides. The house of accused Monidol is located in between two tree houses of both sides. This was the evidence with regard to houses. Now your lordship, see the sketch map, my lord. That's why as your lordship has seen. The sketch map at page 91, my lord.
Scissor list is which page regarding bike?
By page 93, my lord.
From the position of Bhaiti Pego.
Yes. With the PW 3, PW 6.
PW? Bhaiti Pego is PW. 13.
PW 6. Yes. Now, as your lordship has seen, I have already said to the press.
The owner of the bike has not come to the scene,
Yes.
not discussed, that Dimbis or new. Is this the same bike which has been seized? I have very grave doubts.
Was number and all are not mentioned by anyone. Bike of the deceased is.
In fact, my lord, entire proceeding is preceded by, because the my lord, mobile which is seized, it is also not confirmed whose mobile is that. That is also one issue, my lord. The mobile, they have seized the mobile from the, they are saying seized from the accused person. My lord. And it is returned to the my lord, the deceased family. But it is not confirmed in the judgment whose mobile is that. That is not confirmed. So, I'd just like to point out, my lord, because your lordship has seen entire evidence is based on hearsay. Even the PW4, the very argument made by my learned friends, my lord, that the confession is made by one money Pegu, one of the accused, my lord, before public. It is not specifically in front of him, my lord. Who is that public? That is not mentioned. Public is, I was present there. He has not mentioned I was present there. In front of me, that is statement.
Who has said PW?
PW4, my lord. It is there in line, my lord, page 15, my lord.
No, otherwise also Moni Pegu has been discharged
Yes, disturbed. And my lord,
or not discharged, acquitted.
acquitted. Even though, my lord, even though I accept my lord, that Moni Pegu may have something in front of him, my lord, candidate. But whether he was present, he has not said in presence of me, Moni Pegu stated this thing. My lord, he has not said. Only entire evidence is here. They are relying specifically on.
No, if in the, we may also take it in this manner, if on the basis of the evidence, the materials have been found not to be sufficient so far as Moni Pegu is concerned. The same which was more, the culpability of Moni Pegu was more, or was there in this evidence. These evidence, how can these materials be used for your client?
Yes, this cannot be, yes, co-accused evidence, statement cannot be used against my co-accused. Because he was one co-accused in my case. That cannot be used against him. Definitely that will.
It can be used, but there needs to be corroboration.
Yes. So apart from this, my lord, hearsay that is statement, there is no other statement of this kind. The same issue, there is no other. So I'd like to rely only one judgment, my lord. Regard to, because this is my lord. With regard to this circumstantial evidence, my lord, what should we see? 1984. Yes, yes.
153 paragraph.
Yes, yes, 153. That is that.
Panchashil.
Yes.
Panchashil.
Yes, sponsorship. That has been affirmed again and again, my. So there it is clear, it should be, the fact should be established, my lord. Beyond the zone. So may and sale, there is distinction between may and sale, my lord, is clear. That is established even in 2022 also, my lord, another judgment 2022. In fact, in that case, though it is acquitted, it is convicted, but it has been asserted, asserted that this principle has to be followed. So what is it? Nothing has. Once fact is proven, then it can be inferred some extent, something may be inferred, but nothing is inferred. So my submission is, my lord, along with Mr. This judgment, which I have just now. It's clear case that conclusion is made, without analyzing the evidence properly, without and it's actually illegal. So my submission is that appeal may be allowed, the plan may be
Heard PJ Bank, your responses to that. Also have Ms. Jahan. Then EPP Assam. Ms. M.K. Brown, Learned Legal Counsel, is present for the respondent in this case. Well, hearing is concluded, judgment is reserved. Yes.
I paid it to.
Okay. Item number 5. Okay. Sri Upadhyay, the Learned Standing Council dedication.
Then,
We can close it if it's, we record his, this, no, this is there. We'll close it. Oh, obviously, we'll direct it. Heard 3 ME6 Learned Counsel for the petitioner. Also heard 3. Upadhyay, Learned Standing Council Education Department. Anybody was finance department in the court? Finance department. As well as 3 Chaliha, Learned Standing Council Finance Department. The matter pertains to the pensionary benefit of the petitioner who had retired as a helper. 3 Upadhyay, the Learned Standing Council, has however submitted that immediately after institution of the writ proceeding, the matter was settled and she has in fact placed before this court this is PPO, the PPO, which was issued in the year, issued on 24/8/2022 itself. Full stop. He has also, the same PPO also includes the communication of the same date to the Treasury Officer Gwalpara regarding the onward action. Full stop. Though Sri MSA Learned Counsel for the petitioner submits that he does not have the instructions of the same development, noticing the aforesaid development, this court is of the view that there is no reason to keep this writ petition pending. Accordingly, the same is closed. The copies of the PPO with the enclosures presented to the court are made part of the records. The said copies are also to be given to Sri Sheikh, the Learned Counsel for the petition. Yes. Yes, question. Yes. Withdraw. Okay. Year for MR Adhikari SC soil conservation. Is he still there? Soil conservation, I think. Presently, I think is soil conservation is Mr. SRM. Okay, you are there. Okay. Heard MSRS Chaudhary, Learned Counsel for the petitioner. Also heard your name?
Yeah.
P. Hazarika, Learned Counsel, appearing on instruction of 3 SR Standing Counsel, Soil Conservation Department. Para. Ms. Chaudhary, the Learned Counsel, submits that she has instructions not to press this writ petition. Para. The aforesaid submission is not opposed by the Learned Counsel for the respondent. Para. The writ petition accordingly stands disposed of as not pressed. Disposed of, closed. As not pressed.
Item number 3, madam.
Yes,
I am speaking on behalf of respondent number 5.
yes,
So we are supposed to file affidavit in opposition.
yes, Mr. Ahmed. You need not come, anyone? We'll record your name. Okay, okay, well, we'll record your name, no problem, we'll save your seat.
It is a stand for helping us. 2 weeks standing.
For which respondent?
5.
5, and Mr. Roy?
I feel the 2, 3, 4.
Filed affidavit.
Directed against the.
And you have filed affidavit.
I have already now.
But respondent number 5, 2018 matter, why should we grant time?
They are performed.
Why should we grant time? In 2025, what is the justification not filing affidavit from 18 to 2025?
Yes, my God. 2 weeks stand.
No. If you have a difficulty today, we'll have it on the Wednesday next, but not beyond that. Heard Sri M.J. Ahmed, Learned Counsel for the petitioner. Also heard Sri P.K. Roy, Learned, what senior counsel, senior counsel for the respondent number 2, 3, and 4. Para. Your name?
Yes, Chauhan.
Sri S. Chauhan, Learned Counsel for the respondent number 5. However, placed for some time to file affidavit. Para. Considering that this writ petition is pending since the year 2018 and affidavit has not been filed, coupled with the fact that the said respondent number 5 is a pro forma respondent, this court is not inclined to accede to the aforesaid request. However, for the interest of justice, the hearing is deferred. Hearing of consideration of this matter is deferred to Thursday next. Thursday will not grant any time. Thursday date. Thursday is what? 8, yes, 8, 5. Yes, Mr. 2. PJ Dutta.
Yes.
Anyone GA Assam? Go and look at Mr. Dutta. Any GA who is present in the court? No, you did not call. You tell us, we'll record his name. Who's there? Okay. PJ Dr. Leonard counsel for the petitioner submits that he has instructions not to press this writ petition. Correct? Also heard Sri Ardhar Leonard, State Council, who does not have any objection. Correct? Writ petition is accordingly dismissed as not pressed. You tell Mr. Dhar.
Yes, sir.
Okay. Yes, for the other side. Vote for the other side. Guwahati University.
And we saw for it, our. And our time when it was good, and we saw for it,
And veterinary department is also there. Where is Madam Kotoki? Okay, we'll have it on Wednesday next. If you do not have instructions, we'll close this matter. We MP Sharma, when it counsel for the petitioners, submits that he does not have instructions from his client with regard to the present case. Full stop. And he accordingly seeks for some time. Correct? In the interest of justice, matter is adjourned to be listed on Wednesday next. Wednesday one, Thursday next. Please inform Madam Kotoki.
Again, 6.
Yes, Mr. Manan. Today is the Panchayat elections. Dhemaji is today. Your senior is from Dhemaji. Hmm? He's from Dhemaji. Who is your senior? Oh, not Mr. C. Goswami nowadays. Okay. Okay, we'll grant some time. C. Goswami is otherwise from Nalbari, not from Dhemaji. That's certain. Okay. No, he was standing council earlier. Now there is a change in the standing council. Okay. Those three YS Mannan Leonard counsel for the petitioner is present. Prayer for adjournment has been made on behalf of Sri T.R. Gogoi, Learned Standing Council, Assam State Housing Board. Assam State Housing Board. Correct? Considering the aforesaid request. And has accordingly paid for some time. Considering the aforesaid request, the case is adjourned to be listed on Friday next. But Friday will take up for disposal, all matters. Item 7.
As like people have therefore, this direct, this is like on the list.
Now, what about the petition number 1? You proceed with the petition number 1. 2 we are not considering. 2 has passed away. 1 will consider. What is the case? Regularization.
Yes.
As tax collector. Yes, Mr. Doctor. What time? When 21 matter after 4 years, you are praying for time to file affidavit, and you think this court will grant you time?
They are only taking the benefits of open the statement.
Are they still in service or not?
Yes,
Hmm?
they are getting the open the benefit members. That's 3 weeks time.
No, not 3 weeks time. We cannot grant you 3 weeks. We'll have this on Friday next. Affidavit or no affidavit will take up for disposal. Friday, you read the brief properly. You have opened us. You have Karnataka case. Uma Devi. What is the basis of their claim for regularization?
I know they are saying that they are servicing more than 57 years. That is why they have to.
Now, how did they enter into the service?
For that, my lord, I have to.
Now you get instructions Friday next. Okay, what is your name?
J. Peoples.
J.
Peoples.
Firdos.
Yes.
You are not on record. Part 3, J. Firdos Bennett, Learned Counsel appearing on instruction of Sri N. Saikya, Learned Counsel for the petitioners. Also heard Sri S. Datta, Learned Standing Counsel, ENRD, correct? The Learned Counsel for the petitioners has informed that the petition number 2 has passed away in the meantime, and therefore he will be pressing this case only for the petition number 1. The claim is for regularization of the service on the, which is based on the length of service rendered. Sri Datta, the understanding counsel, however, submits that the petitioners were having the benefit of the judgment passed in the case of State of Assam versus Upendas, reported incidents, and he pressed for some time to obtain further instructions. No, he pressed for time to file affidavit in opposition. However, considering that the writ petition is of the year 2021 and sufficient time has elapsed, the prayer for grant of time to file affidavit. Prayer for adjourning the matter by 3 weeks is not acceded to. However, for the interest of justice, a slight adjournment is granted to enable him to obtain instructions. The matter may accordingly be listed on Friday next.
Possibly 14 or 15 minutes. Because this week my elections are going on. Officers may not be available.
Okay, we'll have it on 15. On 15.
I know.
Good.
I did make something is.
Yes. Review. Yes. Yes.
Actually, I was not aware of listing of the case last night. Lately, mother, he informed me I don't have the copy.
Okay. We'll have it on when? Then Wednesday is the holiday. Next Thursday? Okay. Friday. Okay. Heard Sri A. Ahmed, Learned Counsel for the applicants. Full stop. Though this court in the order dated 34/2025 had directed listing of this case by reflecting the name of SC Health and Family Welfare. Such reflection has not been done. The matter is to be brought to the notice of the registrar judicial to make an inquiry as to why the said direction was not followed. Full stop. Nevertheless, Sri Bora, DP Bora, Learned Standing Counsel, who was incidentally in the who is present, has prayed for some time, as he is not prepared. Full stop. On request, list on Friday next. I'll go line to last one. Yes, Mr. Das and Madam. Though this matter was taken by DB, we had fixed a date so that there is certainty over the matter. 26th of May. I think it will be convenient for you, convey it to the parties. That was not stated in the order passed, but we thought that a date should be given. Otherwise, unnecessary notice will have to be issued.